Have advance directives failed? What is an advance directive? An advance directive is a formally written and legalized statement or document that expresses an individual's wishes regarding medical treatment. They specify what courses of action healthcare providers may or may not take in regards to medical treatment of the individual, if ever the case that the individual cannot express these instructions themselves. Most common written advance directives are living wills. Advance directives can also be formal or informal communications with family members and or healthcare providers. Patients can assign an individual to be in charge of making medical decisions for them, and these individuals are known as healthcare powers of attorney or healthcare proxies. Advance directives have become more important as individuals are given the opportunity to leave clear instructions for their medical care if they are ever unable to express them in the future for any reason. Advance directives began to make an appearance in the late 1960s to the late 1970s. In 1969, Lewis Kuttner, a law professor, proposed the idea of the living will. In 1976, California enacted the first law approving the use of living wills. In 1983, the President's Commission for the Study of Ethical Problems in Medicine and Biomedical Behavioral Research introduced a new approach of naming a healthcare proxy or power of attorney. In 1990, the case of Nancy Cruzan, a young woman who was left permanently unconscious after a car accident, made headlines. Her parents sued to have her life support removed, claiming this is what Nancy would have wanted. After the Supreme Court required a high standard of evidence of patients' preferences before withdrawal of treatment. In 1991, Congress passed the Patient Self-Determination Act. This act required all healthcare providers under Medicare to inform and encourage patients to exercise their right to sign an advance directive. The act was intended to promote the use of living wills in hospitals and nursing homes. Today, every state has some form of policy providing for the living will. Living wills are widely supported and promoted by legislators, doctors, and social workers. However, such documents and their implementations are rare, as roughly 18% of individuals in the United States have living wills, and 68% of such living wills are misinterpreted, misplaced, or ignored by healthcare providers and proxies. So have advance directives failed? Yes, they have. Psychologist Angela Fargelin and law professor Carl E. Schneider posed the arguments that the living wills seem to not affect patients' treatment after analyzing much empirical evidence, because the wishes of patients fail to be implemented. Also, although Fargelin and Schneider believe healthcare powers of attorneys are the better solution, scholars such as Samir Karnik and Amar Kanikar believe that not only have living wills failed, but advance directives in their entirety, including assigning healthcare proxies, because even in such cases are the wishes of individuals failed to be met. This leads to the empirical questions about individual self-autonomy in making medical decisions. Interpretation and implementation of advance directives constantly fail. Just because they exist does not mean they will effectively be adhered to. There is direct evidence throughout history that living wills fail to have their intended effects, according to Fargelin and Schneider. Healthcare providers. One study showed that 25% of patients in an unnamed hospital received medical care completely inconsistent with their living will. A myth states that advance directives are legally binding and healthcare providers must follow them. However, the fact is that advance directives are legally recognized. This means that doctors are urged to respect them but are not required by law. Doctors are able to disagree and ignore them if they deem the instructions medically inappropriate. Healthcare providers can refuse to comply if they disagree with the instructions. Often, instructions given are vague and difficult to apply to current medical situations. In these cases, which are the most common, physicians do not outrightly choose to ignore a patient's instructions as described in the advance directive. However, the language used in the instruction provided are often misinterpreted because of their vagueness or how outdated they are, and therefore are not carried out as the patient would have wanted. Assigning a healthcare proxy. Healthcare proxies could be assigned with or without the existence of a living will, and this seems to be a way to clear up the murkiness of a vague living will. However, proxies are most commonly loved ones of patients and are emotionally attached to the patient, and their moral interests may weigh heavily on their opting for treatment or declining it. Many surrogates are also not able to accurately interpret the wishes of the patient because they are authorized to speak on their behalf and sometimes given no instruction about exactly what it is the patient wants. A study even showed that 70% of proxies fail to accurately interpret without previous consultation about the living will what it is that the patient wanted for medical treatment. And participants who did have consultation about the living will beforehand did no better. This disproves the misconception that loved ones can make proper informed decisions simply because they know the patient well. What is often overlooked is how common it is for proxies' own misinterpretations, emotions, and interests to influence the decisions they make on behalf of the patient. The ethical question that arises through all of this is, where is the self-autonomy? In light of the issues surrounding the misinterpretation or disregarding of the wishes of a patient, ethical questions are raised. Through the failure of advanced directives, Kant's deontological theory has been violated. According to Kant, every rational individual possesses an autonomous, self-legislative will, and it is the duty of every individual to treat other individuals as an end in themselves and respect their autonomy. These duties include the duties of physicians and healthcare proxies to respect and uphold every instruction the patient has described in their advanced directive. This allows patients to make rules for themselves, direct their actions, and consider the consequences before making any rational decisions. If persons are human beings with moral status, then the loss of the ability to display certain empirical properties, such as the ability to make medical decisions for themselves, does not make them non-persons. The flaws in advanced directives have made abiding by the ethical guidelines described by Kant very difficult and have led to numerous violations of the ethical theory by physicians and proxies. Policies and legislators have allowed far too much wiggle room in the implementation of advanced directives, and although they have been praised and upheld as standards of care for decades, it is time to recognize that they are ethically unsound and need to be modified and corrected, so there is very little chance that a patient's instructions will be deviated from. This includes the process of legally creating living wills and naming healthcare proxies and providing them with instructions. The patient's dignity and moral status are undermined as healthcare providers and proxies project their own ideals, morals, and autonomies upon the medical decisions and act contrary to what the patient had instructed, blocking their expression of self-autonomy. It is not up to these second-party individuals to override such decisions, and due to this, advanced directives have indeed failed.